Hello, good afternoon, everyone. My name is Ryan Conlin, and with me is my partner, Jeremy Schwartz. Today, thank you for joining us at the Stringer LLP webinar on a topic that has been all over the news these days and is going to be an issue that I'm actually very glad that we're going to be dealing with in 2021 after a year like no other. The focus of our webinar is, as indicated, the long and winding road. That we're going to take a look at the health and safety issues that arise and employment issues that are arising in the pandemic. Specifically, we're going to spend a fair bit of time focusing on the issues arising from the new vaccines, which have received approval in the United Kingdom and are about to receive emergency approval in the United States and here as well. And so ultimately, it appears that we're going to be confronting a world where there is going to be an end to this. But of course, we know that when it comes to vaccines, there is a significant degree of disagreement, perhaps, and political controversy in some cases about how that's going to roll out for people that don't wish to take it for whatever reason. And we're also going to be taking a look at, in some depth, the privacy issues that are arising and probably taking on more prominence than they ever have, as far as they pertain to vaccinations and other issues coming from COVID-19. Jeremy and I are going to leave some time for questions. Those of you who have been on our webinar before know how to do that. You can take a look at the if you can't see the question box, there's a little orange arrow. Click on that arrow, and then I think it's fairly self-explanatory from there. And Jeremy and I will entertain those questions at the end, and we'll try to we may not get to all of them, but we'll do our best to get to as many as possible.
One point I noticed, there's only one individual, but just in case it's anyone else, advising that the volume isn't working. It is working based on our tests right now. It does appear to be working. So if you are not having that working, you might try logging out and logging back in, restarting your computer, or ensuring that your sound is properly configured.
Okay. So Jeremy, I'm just seeing here like that these slides aren't moving for me, so I'll try that again.
It should work now.
Okay, there we go. All right, so as the first topic we're going to take a look at is the issue of vaccinations. As most all of you certainly know, COVID-19 vaccines are being approved literally all over the world. Of course, different vaccines are at different stages of approval and require different dosages, different methods of storage. So it's still in very early days in terms of how vaccines are going to be distributed. At a high level, the federal government has confirmed that almost all Canadians should be vaccinated by this time next year. Obviously, that process is contingent on the vaccines being properly distributed and a lack of a crisis and things on those lines, or some unforeseen complications that arise from them. But that seems to be the case that by this time next year, everyone should be most people should be vaccinated. Obviously, exactly what the priorities are for the early vaccines aren't crystal clear, but it certainly appears fairly certain that first responders, staff in long-term care homes, correctional institutions, and individuals at high risk, which is basically elderly people and people with certain comorbidities, will be prioritized. And the exact framework, of course, for that remains to be seen. So the bottom line is, how is this going to impact employment law? How is this going to impact and the question that's been thrown at me, I don't know how many times this week, quite a bit, is once the vaccines come out, is an employer going to be basically allowed to say that unless you have the vaccine, you're not allowed to come into work? We don't know of precisely what framework the government is going to respond to this. But we do have some hints that have come out of some fairly senior people in the government. And this is a quote on the screen from a very recent quote from Christine Elliott, the Minister of Health in the Ford government at Queen's Park. And she basically indicated to a media source that there may be some restrictions placed on people that don't have vaccines for travel purposes, to be able to go to theaters and other places. That will be up to the individual to decide whether or not they want to receive the vaccine to be able to do these things or not. So certainly, if you look in that framework, obviously the minister wasn't speaking specifically about employment law, which is for most employers, is a provincially regulated matter. But She certainly, but you can take, if you're reading between the lines, it's certainly been made clear that the government's looking at a framework where there's going to be a process of identifying, giving people records of who have had the vaccine, a so-called vaccine passport, perhaps, and that the government may be willing to sanction certain restrictions in certain environments. She specifically mentioning things like travel, where I think it's going to be pretty clear those that are traveling across international and perhaps even provincial borders may require a vaccine passport, and certainly it seems likely that for large public gatherings such as sports stadiums and movie theaters and others, that though these kind of restrictions are going to be endorsed. So it would seem to me, just at the highest level, it seems unlikely that that these kind of restrictions are going to be allowed to be in place for things like theaters and sports stadiums, and not in some respects employers, remembering that every workplace is different in these facilities. The next comment, the reality has come from David Williams, who's the Chief Medical Officer of Health in Ontario. He has said what we can do say is sometimes for access or ease in getting into certain settings, if you don't have vaccinations, then you're not allowed into that setting without other protection materials. So, I mean, that could be interpreted to say that there may be some exceptions for people that choose not to get vaccines if they're able to socially distance, if they wear masks. So there may be some talk along those lines, but I always want to remind people that law is a very practical. Believe it or not, it's very practical at times, and I think the practical reality is it's going to be difficult for individuals who aren't vaccinated, provided that there isn't widespread side effects that we're not currently aware of. I think that you're going to see a large consensus, given the overwhelming impact that COVID-19's had on our economy, that it's going to be difficult for individuals to assert that they should be entitled to access a workplace, particularly indoors, without vaccinations. Currently, that is something that I would have a hard time imagining that's going to be the case, subject to very limited exceptions, just given the impact of COVID-19. We certainly, just as a reminder for some of you, those of you who have children or went to school in Ontario and most other jurisdictions would be familiar that compulsory vaccines is something that's been in law in terms of attending school for many years. If you look at the name of the legislation, the Immunization of School Pupils Act has a certain sort of Victorian quality to it, very antiquated name. And so looking at that, for those of you, it's very straightforward. I mean, basically the Immunization of School Pupils Act requires children who are students who are attending schools in Ontario to prove that they received specific vaccinations. This is very old, and it only relatively recently has become somewhat controversial in some circles, based upon some folks relying on what I understand to be pseudoscience around certain side effects of vaccines. But there has always been exemptions for medical reasons, if you have a legitimate medical basis not to have it, or due to conscious or religious belief. And if you look at, and every school board in Ontario has a process for filling out a form that addresses all of those issues. I would be quite surprised if the COVID-19 vaccine was not added to this legislation. It seems self-evident that the legislation would be amended to include COVID-19, potentially likely subject to the same exemptions that are currently in place. All right, so here's the $1 million question, and it is obviously obviously it is a question that has no certain answer at this point. An employee, the one thing I can say is crystal clear is that an employee can't be forced to be vaccinated. It seems that the government is not going to take the steps of forcing someone to put something in their body they don't wish to. That would be an almost unprecedented violation of someone's rights that are guaranteed by the Charter in Canada, and public officials at the highest levels have come out and said, you're not going to have to be vaccinated, but as the medical officer of health said, that if you choose not to, there's going to be certain consequences that flow from that in terms of what you're allowed to do. So it is perhaps from the perspective of some that maybe you're not officially required to, but your life and your ability to conduct your life as you're used to without vaccination might be more difficult. And this raises the question of which clients have been asking is, can an employee be terminated for just cause for refusing to be vaccinated? And let's assume for a moment that employee isn't asserting human rights grounds about that. We'll get to that issue later. And the bottom line is no one can say for certain whether that's just cause or not. Ultimately, that would be a very fact-driven exercise. It would depend upon what type of evidence the employer could lead that as to, first of all, why, even if it's not human rights, why is the person refusing to get vaccinated? What alternative can the person work from home? If they were working from home before the pandemic, why can't they just continue to do that? I mean, it's a little less complicated. It's like the person's required to come into the workplace, can't work from home. But even if they could come into the workplace, is there a way they could do so safely? Could they wear a mask? Could they socially distance? Those kind of things. And of course, and we'll get to in a moment, there's sort of the flip side of that coin about what the consequences at the workplace are if someone is openly refusing to get the vaccine. I think one of the things that, from Jeremy and I's perspective, we think would really be helpful is I would really think it's important that the government step up and show some leadership on this issue and not just toss it over to the courts for employees to find out what's going to happen if what a particular judge thinks is the right thing. I think to me, it's an issue of such public importance that it's very much like the schools, that the leadership should come from the top, and that a legal framework under the Occupational Health and Safety Act, under the Labor Relations Act, however you want to deal with it, that should apply province-wide to the provincially regulated economy, which is approximately 90% of employers that are subject to provincial regulation. So it remains to be seen whether the government will actually do that. There's certainly been situations where the government seems to enjoy sort of, pushing off the controversial topic to the courts. But I'm hopeful that isn't the case, and it will be interesting to see if there's sort of a coordinated national response as employment law is provincially regulated. So as is the case now, for those of you who have operations outside Ontario, you could be subject to potentially to different rules depending upon the jurisdiction that you're in. Lastly, I mean, people have asked us a bit, well, how does the charter fit into all this? And the charter is a very complicated and entire field of study for lawyers. But the bottom line is, just to summarize it, I don't think there's any question that there's going to be, if there is any type of mandatory vaccination rules in an employment context or frankly otherwise, there's going to be challenges to the charter under various grounds, such as the charter right for life, liberty, and security of the person, the fundamental right to fundamental justice. But without getting down into the weeds of making everyone go to law school, the bottom line is there have been these kind of charter challenges to vaccinations, to blood transfusions in the context of Children of Jehovah's Witnesses. There has been this kind of litigation at the charter level before. The bottom line is that the Canadian Charter of Rights and Freedoms contains a well-known section called Section 1. And what Section 1 does is allow the government, even where a court finds that a government action is a violation of someone's charter rights, that can be justified by the government if it amounts to a reasonable limit. That basically the government basically said the charter allows the government to violate people's charter rights only if it's reasonable. And what reasonable means is a very long and torturous legal exercise. But at a high level, I think it is very likely that a court would find that restrictions on travel, school attendance, even potentially employment would likely be a reasonable limit. I think a court would be somewhat reluctant to interfere with a statutory regime, unless the government really way crossed the line on it, and different provinces may respond to it in different ways. But it's my view that charter challenges, at least of the process in terms of having a vaccine passport to access certain facilities, will more likely than not survive charter scrutiny. But I think you can anticipate that kind of litigation will occur. All right, so I'm going to pass over the conch to Jeremy, who's going to talk to you a little about the privacy law side of this issue.
Thanks, Ryan. This may be, suppose Ryan's topic is a touch more exciting. It's present for all employers right now. Over the next, for some employers, it'll be very soon. For others, it will be over the coming 6 to 12 months that this gets rolled out. And of course, as Ryan said, it doesn't appear that we're getting, at least at the early stages, any guidance from the government. We're hopeful that we do, but I guess I'm not as optimistic that we're going to receive that guidance, although I think it's long overdue. in light of the way the government has treated some of the other aspects of either testing, masking, other reasonable precautions, and ultimately the guidance that has been provided to date in those areas has either been quite slow in coming or very broad, and in some cases impractical. But let me take you through these sort of the privacy considerations as it comes to workplace. First of all, we're not talking about privacy in an esoteric way here today. We're talking about privacy from a legal perspective. And a lot of folks forget that privacy is not something that just exists. It's essentially a legal construct. And the courts or the tribunals or the legislatures or parliament have created various iterations of that legal structure. So I think it's important to start with what does the law say? What laws do we have? There is a law called PIPEDA, which is a piece of federal legislation that essentially deals with the protection of your personally identifiable information in primarily government and commercial endeavors. And long ago, courts, tribunals, arbitrators have held that the workplace is not a commercial endeavor. And as a result, PIPEDA does not, because it does not affect, outside of government at least, does not affect employment expressly, but rather simply government and commercial undertakings. PIPEDA does not apply. Okay, so that's very important. A lot of people forget that. They think PIPEDA applies to everything. It does not. One thing PIPEDA did was it allowed individual provinces to create their own privacy legislation. And if they did, then PIPEDA wouldn't apply. Privacy is one of those civil rights aspects, and under our Constitution, generally the provinces have that power to govern civil rights. And as a result, what the federal government did is under PIPEDA, they said, okay, we see this vacuum. The provinces haven't enacted privacy legislation. We think they need to. So we're going to create this law, and we're going to say that it applies unless the provincial governments create their own. And so the ones that created their own are simply BC, Alberta, and Quebec. Those three provinces expressly included workplace privacy considerations. And so when you are when you have operations in BC, Alberta, or Quebec, you'll be well familiar with the various obligations, which are quite similar to the general obligations that we'll discuss in a moment, but they are expressly applicable to workplaces and the employment relationship. Outside of that, other provinces, including Ontario, there is no express legislation that specifically governs the workplace. And so the arbitral jurisprudence when it comes to things like drug testing, when it comes to surveillance, when it comes to the privacy of employee information within the working environment is very different in Ontario and other provinces that don't have their own legislation. And that's very important for people to keep in mind when they're looking to the statutes to determine where do these privacy rights come. One aspect of sort of the legislative sources that sometimes is forgotten when we're analyzing these various issues are that there are pieces of legislation in every jurisdiction that will have an impact on privacy at various stages of the employment relationship. For example, health and safety. There are a number of aspects to health and safety obligations that employers have in every jurisdiction that may have an impact on workplace privacy during COVID in particular. For example, there is a general duty for all employers to take reasonable precautions to ensure that their workplaces are safe and their workers are kept safe. And so what does that mean? Well, in no jurisdiction as yet do we have specific COVID-related regulations under health and safety when it comes to masking or testing or temperature taking. But the question arises, and we've covered this in previous webinars, would it be a reasonable precaution for an employer to require those things to happen if it's not expressly required in other pieces of legislation? And so one of the issues that arises is, okay, let's say that you are advised by your employee that they have COVID or that someone at their home has COVID, or that seemed to have happened, especially in the early days, someone in their family returned from a vacation or a work trip out of province or out of the country. What are you supposed to do about that? Well, in terms of dealing with the practical aspect, there's law on that, and we're not here to talk about all of those sorts of leaves and things like that today. But from a privacy perspective, if you have an employee who is in your workplace, who has had contact with other folks, who is telling you that either they or someone they've had contact with may have been exposed or may have been tested positive for coronavirus, you then have to take steps to protect all the workers that they've had contact with. And so the question arises, well, how do you do that? Do you advise the other workers that they were in contact with Bob and Bob has tested positive? That may be unlawful. That may be something that you don't have to do. And we'll talk a little bit about how you make that judgment call. But certainly you have to give the employees and possibly the Joint Health and Safety Committee sufficient information so that they can help ensure their own health and safety and the health and safety of their families. So the second issue that comes up under, again, just general health and safety principles, in most jurisdictions, there's an obligation when someone is subject to an occupational illness or disease that they contracted in and of the course of employment, and that's critical. It's not just something they caught in the community and came in with, but that's something that they likely, or it appears they have likely contracted in the course of employment or at the workplace. You then may have obligations to report that. In Ontario, within 4 days, if someone contracts an illness in the workplace, you have to report that to the Ministry of Labour, you have to report that to your union, and you have to report that to the Joint Health and Safety Committee. And so what is it that you have to report? Well, certainly to the ministry, you'll have to provide the name. Whether or not you have to provide the name of that individual to the Joint Health and Safety Committee or to the union, that will depend on the circumstances. And again, we'll talk about how you sort of sift what needs to go to which group. But that's, I think, another important aspect. Another aspect of health and safety is not directly under the Health and Safety Act, but actually arises out of the mandatory screening rules that are effective essentially right now across Ontario and similar laws across the country, where any operator or any person in control of the premises has to ensure that they do certain things to screen people before permitting them to enter. And so whether that be employees, contractors, agency workers, or visitors. So you're now obliged by law to undertake these assessments, which inevitably include the collection and assessment of individuals' personal health information. And then the question arises, okay, so you have to prove that you are complying with these rules. Are you then going to record the information and your objective assessment or the information that is being self-reported by the individuals? Are you going to preserve that personal health information? These are important questions that arise directly out of these government obligations that apply to basically every workplace because they apply to everyone in control of an indoor public space. And yet the government has not provided sufficient guidance, in my view, although the Minister of Health and the medical experts and officials have given us guidance on what screening would be appropriate. They have not given us guidance on the privacy consequences of the undertaking we're now being obliged by law to undertake. And I think that's unfortunate. And I think employers in particular need to pay careful attention to what it is they're collecting, why, and how they're storing it. And we'll talk a little bit about that in a moment. The WSIB workers' compensation aspect of this, we've got a lot of, there was a lot of to do in Ontario early on, where there was a private member's bill to create a rebuttable presumption that if someone is working, not remotely, but is required to go into work and they contract COVID, there would be a rebuttable presumption that they contracted it in the workplace. And then you'd have to deal with that and you'd have to find evidence to show that that was not the case because it was a rebuttable presumption. And that has died, and I don't believe that it's likely to be resuscitated, that particular bill, but we'll see. And if that comes up, that may create new and additional privacy issues. From a contract side, there is an issue concerning the imposition of a term and condition of employment. So where the government has not expressly required you as an employer to undertake certain kinds of pre-screening, whether that be temperature checks or whatever, if you've determined based on the situation in your circumstances, based on public health recommendations or recommendations in your industry and sector, that it would be a prudent and reasonable precaution to ensure the health and safety of your workers to require them to submit to a infrared temperature test on their way into the door. Will that be a violation of their employment contract if they're not unionized? And as Ryan suggested, the law is quite different between unionized and non-unionized employees. In general, when you're non-union, employers can impose reasonable and lawful conditions on employees coming into work and being able to conduct their affairs, provided that there isn't a contractual or statutory basis for making that unlawful. Now, whether that means that someone who refuses a test or fails a test can be denied employment or simply has to take a leave is another question. And so too is the question of whether you can terminate someone's employment with or without cause. So whether you can create a new condition of employment that didn't expressly exist before, and then terminate someone for not meeting that condition or refusing to cooperate, those are entirely different questions. From a labor perspective, of course, there's the KVP test, which those of you who are unionized will be well familiar with. But essentially, that test is a requirement of reasonableness on the part of management when exercising management's rights, which are the rights that are reserved to management that are not inconsistent with express provisions of the collective agreement and are otherwise generally perceived in the jurisprudence to be part of sort of that basket of management rights. And so a real issue there, and we've seen this play out in a couple of cases that I just wanted to flag for you. You might remember in 2013, the Supreme Court of Canada came out with a case, the decision in Irving Pulp and Paper. Very briefly, this was a case where they had a random alcohol and drug screening policy. This case dealt with the alcohol side of that policy. And some comments from the Supreme Court, I think, are apt in our situation here. The Supreme Court said that random testing, which is essentially what temperature taking and other forms of screening and those sorts of things are, these are a serious intrusion on the privacy rights of an employee that are only permissible where you have a historical problem. And not only that, you have to demonstrate that your solution, the test, is not only likely to be effective in determining the results at the time, but also the choice of having a test at all needs to be a minimally intrusive method of conducting that screening, and it has to be conducted in a reasonable manner and consistent with the human rights of the individuals. So a pretty high bar was set there. Some will also be familiar with the TTC case, in which Ontario Superior Court dealt with the question of whether the TTC's new drug and alcohol policy, specifically here, the drug side was under the microscope, which allowed for random drug testing to be conducted for all TTC frontline employees and operators. And the arbitration where the union had objected to that policy before it was implemented had gone on for a number of years. And the TTC said, enough is enough. We're going to implement this policy even though the arbitration has not completed. And the court allowed the TTC ultimately to do so. But some of the comments there, I think, are also going to be helpful here. What the court essentially said was the TTC had been able to demonstrate that there was clearly a serious problem that it had to address. So it had a history of drug and alcohol related either accidents, near misses, or incidents. They had established an unintrusive test where the employees were simply swabbed and would go into, they would do so in a private area. The employees were not automatically terminated or put on leave. Following a positive test, there was a whole process that was involved. They were offered employee assistance and all that sort of thing. And so essentially what the court said in that case was weighing the potentially fatal catastrophic consequences of someone driving a bus or somebody operating a subway being under the influence against the, again, using the Supreme Court's own language, serious intrusion on the employee privacy rights. The TTC decision in that case, again, this is an interim decision. The court said when weighing those two things, that it was sufficiently pressing and that it was reasonable to allow the employer to implement that, again, on a sort of temporary basis. So I think that's quite important to keep those sort of sources of privacy and how these things may arise in the COVID context in place. Now, then the privacy principles, and these are the ones that come out of not only PIPEDA, but the general literature concerning privacy in general, not just in the workplace. You have to have legitimate, and you have to identify the purposes for the collection, use, and disclosure of whatever it is that is personally identifiable information that you are collecting, using, and or disclosing. You have to identify that to the individual that you are disclosing, that you are collecting, using, or disclosing their information in general, or it has to be implied that you are doing so. They have to consent to it, either directly implied, or there has to be an exception to that. You have to limit the collection, use, disclosure, and retention as required for the purposes. So you should not be collecting information you don't actually need. You shouldn't be disclosing it or using it if you don't need it. And you shouldn't be retaining it any longer than you need to for the purposes that you've identified. If you have collected and you're storing information, you have an obligation to safeguard that information. So if you are collecting people's assessment forms on the way in the door, if you are taking their temperatures, if you are recording that information, if they have advised you that they, or a loved one or someone with whom they've had contact with has been exposed or has been found through a positive test to have COVID-19, then you now have this personal health information, and you are, if you're going to retain it, obliged to keep that secure from third parties. You have to enable those individuals to access what information you are storing that is theirs, and you have to permit them to have some method of challenging your compliance with your own policy and ensuring that that information is accurate. So, I mean, again, we've spoken about some of these things, but in general, we've got a number of aspects where privacy is getting engaged practically as a result of COVID. Number one, access temperature checks. Whether you're going to allow employees or visitors onto your property, there is at least some literature that suggests that some employees, or that some individuals rather, will have a heightened temperature if they are suffering from COVID-19. Of course, that may be for any number of other things, and many people are asymptomatic, or having a fever is not actually a symptom that they suffer from. So there may be a live question about whether that is an effective means. Of course, some employers have put those in place, and there are some places where you can't get in. For example, if you wanted to fly, then you would not be able to go unless you had that temperature check done. Mandatory infection contact disclosure. So this is something where the government has mandated that employees advise, that everybody advise when they want to access a facility, whether or not they have been in contact. And so this sort of helps you. You're permitted to ask that question and gather that information. And of course, there's contact tracing and employee notification, as we discussed. What happens if you become aware that there has been a COVID outbreak, even if it's just a single individual within your workplace? Adjudicating those exceptions, so dealing with the questions of whether an employee must wear a mask, must socially distance, can work from home, if they have accommodation requests because they have eczema or because they have a respiratory condition or a heart condition such that wearing a mask would be dangerous for them. The question is, well, are you allowed during the accommodation process to deal with those on the privacy, in terms of the privacy implications of that information? And so there are some regulations that deal with this. For example, the Employment Standards Act provides that employees who wish to have infectious disease emergency leave are not required to provide a medical note in order to take that leave. Of course, the flip side of that, though, is the law does not restrict employers from prohibiting or requiring employees to provide a medical note if they want to get paid for that leave, whether that be under a sick, STD, or LTD policy that's in place. So it's sort of a fine line, but the employee may be entitled to take that leave without proving to you with at least a medical note that they are eligible, but you don't have to pay them, even if your sick leave policy provides for pay during a sick leave, unless they comply with the obligation to provide that medical during your sick leave, because that's a greater right or benefit. The ESA's minimum rules, in my view, don't apply. Another issue is, for example, that requirement for the operators or those responsible for a premises are not required to show you a medical note or in order to demonstrate that an exception to them wearing a mask applies. I think that is a glaring oversight and something that the government really should close the loophole on, because it's being abused all over the place. I've seen personally a number of examples. At the LCBO recently, I was standing in line and someone turned to me, as like 17-year-old kids standing with 3 friends, none of whom were masked. And they all said, yeah, we don't have to wear masks. We all have medical exemptions. I found that sort of hard to believe, but there was nothing we could do about it because the law is the law as it stood. But does that apply when it comes to employees who are seeking accommodation? And the answer to that is no. So to seek the accommodation, they do have to provide you with evidence that they have a medical condition, or that they in order for them to, or they have a restriction. They don't have to give you the actual condition, but the nature of it. All those typical rules do apply. And there are no privacy rules, and there's no legislation that restricts an employer who has to engage in that accommodation inquiry, whether it be masks or gloves or hand sanitizer or what have you, social distancing, to require that employee to provide the ordinary medical information they would be required to provide to demonstrate what functional abilities and limitations they have, and to properly engage in that accommodation inquiry. And I think ultimately this is sort of an interesting case that came out that dealt with the question whether employees at a chicken processing, meat processing plant were required to mask up, or whether they could wear face shields and try to social distance, which of course wasn't possible there. And ultimately, the Ministry of Labor told this employer that they had to require everyone to wear masks, despite the employer taking the position that in some cases wearing a mask would lead to greater risk. And the board was willing to say in this, and I have the quote here, in this dynamic and evolving situation, that we're going to keep evaluating the science on this, but essentially that the risk of not requiring these precautions to be taken was far outweighed the harm done, or the risk of allowing people not to wear a mask. And the consequences of wearing a mask. So you combine those together, and I think that the precautionary principle will give us a bit of guidance on where we go from here. Ryan?
Thank you, Jeremy. It was some very interesting insights into an area of law that we don't often think about in Ontario as much as they do perhaps in some other jurisdictions. I'm going to shift gears to work refusals. Again, this is a right that we've heard a lot about in the context of COVID-19, and something that, especially outside of unionized environments, is not usually a top of mind. But ultimately, it's a provision, a well-established provision under the Occupational Health and Safety Act, that allows an employee to refuse to work if they believe they're going to be endangered, and it's very specifically limited to specific things. Basically, in order to engage in work refusal out of fear of catching COVID-19, ultimately the worker is going to have to latch on to the idea that someone's COVID condition is part of the physical condition of the workplace under sub B or sub C. Ultimately, looking at that definition very strictly, when there's perhaps an argument that the physical condition of the workplace is not the physical or health condition of a person, but the legislation is always meant to be interpreted broadly. So the question that arises is, will the other side of the coin to the example I talked about earlier? Let's just say we have a situation of a worker that refuses or is medically exempt from vaccination, is working in person in the workplace. Does another worker, if they become aware of that, then, which I guess if the person's wearing a mask would be pretty obvious, that worker then refuses to come to work until that person's been dealt with. How is the Ministry of Labor likely to deal with that? And let's assume for a moment that even is a work refusal, which I suppose if I were representing an employer in that circumstance, I'm not sure that I would. But it kind of get the control the slide, Jeremy. So ultimately, in terms of ultimately in terms of work refusals, what I think is likely to be the case is that if someone is not vaccinated, that there's going to have to be a situation of physical distancing and masking. And I think, frankly, it's also going to turn on the science, that ultimately we're going to know more and more and more about COVID as time goes on, and to what the actual value of a mask is. And not just the value of a mask, but which particular mask, how it's fitted and worn, and all those kind of things that have sort of, fallen by the wayside recently, where people have come to the conclusion that just basically any 99-cent mask that someone buys at Walmart will suffice. But I think that if you really look at the science of these things, is there's quite a difference between an N95 properly fitted mask and the one that are being widely used in public. So we're going to have to see where that goes. And again, and maybe hope springs eternal on this topic, that there may very well be some actual guidance, if not even law, but outright guidance from the government that talks about what is an appropriate accommodation as to whether is a worker, in what circumstances is someone who's not vaccinated permitted in a workplace, and what precautions need to be taken, and if so, for how long. I mean, at some point, I guess the reality is we all know that at some point, hopefully, we're at a herd immunity point where all this stuff no longer matters. But we're probably a ways away from that. I mean, certainly, so it's. So the bottom line is, when it comes to work refusals, what would happen is the Ministry of Labor will be engaged. And I think what you're going to find, like, just again, speaking practically, much like with COVID, much like with the earlier stages of COVID, the ministry, I think, is going to come to a policy decision as to what it is they're going to accept or what it is that there isn't, unless you're in a very, very factually specific workplace where people are in really close proximity or ventilation issues. There'll be some differences from workplace to workplace, but I guess the one thing that I can tell you that we certainly learned from the teachers union case law that came out of the labor board recently is, if an employee wants to challenge the physical condition of a workplace, they have to do it workplace by workplace, issue by issue. You can't, as like the teachers union did, just try to say, let's bring one appeal for all schools in Ontario, which will certainly come as a relief to larger public sector or private sector employers that have multiple locations and multiple issues. If anyone wants to litigate one of these issues, it's going to have to be done on a workplace specific basis. Moving on from work refusals, the one thorny issue that's going to come up in the context of vaccinations is the Human Rights Code of Ontario. And the first thing I want to say is that I think there's a misconception about that the Human Rights Code, the Human Rights Tribunal, and I can understand why this is, because it's such a range of cases that they hear. Is basically a tribunal to hear every grievance and concern from every employee, and it's not. It's actually, its jurisdiction is very specifically limited to enumerated grounds in the code. That's what it's that's what its limit. So things that we're all familiar with: creed, which is religion, disability, sexual orientation, those type of things, gender, age, all those various other grounds. And if you have a complaint at the Human Rights Tribunal, you have to ground your complaint in one of these bases of discrimination. And one of the cases that came before the Human Rights Tribunal about 10 years ago was in fact a vaccination case. And the case was about an employee that basically said that he did not want to have the flu vaccine. And that's what virtually all these vaccination cases, the old ones anyway, are about. And he argued at the Human Rights Tribunal that not all healthcare workers were required to be immunized, so that wasn't fair. And the tribunal pointed out, in its decision dismissing the case, just said, look, the tribunal doesn't have the power to inquire to all claims of unfair treatment, but only those specifically identified. And occupation, a claim that you're being discriminated against by an occupation class, in and of itself, is not a ground of discrimination. So from that perspective, the tribunal dismissed the case. So we need to look at the framework of which ground we're ultimately in. Get the next slide. So let's take a look at what the Human Rights Code says. So obviously, if someone has a disability, which is one of the most common grounds that would prevent them from being vaccinated, ultimately, first of all, they actually have to establish that. It can't just be. It has to be a specific. It has to be tied to a specific disability. that employee has, although disabilities are defined fairly broadly. And let's assume the employee gets over that hurdle, and then it just comes down to what's undue hardship, what's the objective risk to other employees. And that's where the traditional accommodation options, such as working from home, masking and social distancing, could be used, should be used could be used as a potential accommodation. Certainly, if someone was working home before the pandemic, I imagine it would be hard to argue that it's an undue hardship for them to work at home after the pandemic. And I think we're going to see cases like that, even perhaps a few self-serving disability claims potentially, to advance a different objective. What about religion? Well, first of all, I mean, there's not a huge number of major religions with significant adherents in Canada that necessarily object to vaccinations. But you have to understand that religion is not just the mainline churches, synagogues, mosques, and other things that other creeds that we're familiar with. The Supreme Court does define it more broadly, and this is the test used by the Supreme Court, basically saying that it's, in using legal terms, it's a nexus with religion in which an individual demonstrates he or she sincerely believes or is significantly undertaking in order to connect with the divine as a function of his or her spiritual faith. So what that means is that someone just can't, quote unquote, make up a religion and say that they and claim that on that basis they are refusing to be vaccinated. That isn't a valid thing to do. But the reality is, I mean, where you draw that line is always fairly tricky. But blatantly self-serving attempts to use faith, to use something that really is not a faith, is not covered by the Human Rights Code. What about the case law? There's not obviously a whole lot of cases dealing with vaccines. Okay, the ones that we do have, all of them come from the healthcare setting of one time or another. They're almost all unionized employers, and they almost all relate to the issue of masking and the issue of whether or not it was appropriate for the hospitals to require the individuals to wear, individual healthcare workers to get an influenza shot, or alternatively, if they didn't get the shot, wear a mask. In those cases, the unions have not always, but generally have been successful in resisting mandatory vaccines. And again, really the test came down to what Jeremy discussed with you earlier, that being the KVP test, is whether or not the requirement, that employer rule, was reasonable. Next slide. And so the one case I just wanted to take a look at is probably the most helpful one, is 2018 decisions from St. Michael's Hospital and the Ontario Nurses Association. The hospital put in a policy that employees in the bargaining unit had to either get a flu shot or wear a mask. And the union challenged that as unreasonable and said that the employer was acting in bad faith, trying to basically enforce a compulsive vaccine policy by making people wear a mask, which, especially at the time this was decided, before COVID, seemed like such a very onerous and not fair thing to do. But ultimately, the union in that case was successful in resisting it. The arbitrator did say the employer acted in good faith, but he felt that basically the mandatory masking requirement, he wasn't satisfied on the basis of the evidence. There was any evidence that masking would offer significant protection. In fact, he just basically said the evidence led by the employer was not at all persuasive, that masks made any significant difference. And one key and important note, which is distinct from the world we're in now, is the arbitrator put pretty significant reliance on the fact that, while these employees were required to wear a mask, the visitors to the hospital were not. So there's hardly a universal masking policy. So it wasn't the world's most compelling case factually on an evidential basis. I am not sure how helpful these, and there's a number of other cases that have been decided in similar ways, one involving Sault Ste. Marie, again, similar. But really, at the end of the day, these precedents are very different. When COVID-19 is obviously has been one of the most influential events of many of our lifetimes. It's affected everybody. You're not going to have a situation where you're going to have a masking policy that, or that's only going to apply to workers and not other people visiting. I think you probably will get some kind. You almost certainly are going to get some kind of litigation somewhere under collective agreements, and most likely outside the hospital sector. But it's quite possible you might get a different decision. These cases are because of what the evidence is and the nature of the issue is very different. Next slide. Just quickly, I mean, we talked about we talked about the concept of union workplaces. Non-union workplaces are different, right? Like they can, you can't really get a so-called interest arbitration, or a policy grievance where you basically litigate whether something's under an employer's rule is reasonable or not. really the only method that an employee outside the human rights context could potentially call in a Ministry of Labor inspector and have that inspector either issue an order or refuse to. And then maybe that would be a way that a non-union workplace could sort of litigate this kind of an issue under the occupational health and safety sort of realm, and that may happen, which again, that was kind of what the teachers union tried to do in the context of sort of a COVID restriction of COVID conditions in schools and such. Obviously, the MOL approach to work refusals will be important. If the Ministry of Labor starts sustaining a bunch of work refusals where someone refuses to work with work in close proximity to someone who is refusing to be vaccinated, that would have a significant impact. And you may very well, again, their appeals of work refusals go up to the labor board. So again, maybe the labor relations board could weigh in on it in that particular context. And certainly certain public sector unions have been particularly active in that in that context. So I'm just going to turn it back over to Jeremy, who's going to take just a quick look at some of the employment law issues.
Right. So this is my letter that I'm going to send to Santa Claus to request that we get all employers get this in their stocking this year. This is my wish list of changes to policies and contracts, both for new and existing employees. As with much of what happened during COVID, it exposed the gaps all over the place in society, legal, structural, and social. And I think that contractually and policy-wise in employment, COVID has shown a lot of employers that they were missing, or that they had provisions that were unlawful, even if they weren't being applied, that are now exposing them to risk when the rubber hits the road, as they say. So I very briefly, just for a minute or so, I just wanted to cover this wish list for you and suggest that everyone consider looking at their policies, looking at their contracts, and wondering aloud and perhaps checking with their counsel whether these are things they should be looking to address as we head into the new year. First, adding provisions expressly, as opposed to relying on some implied right that you think you might have, to impose temporary layoffs, subject to whatever the Employment Standards Act says. This is something a lot of employers tried to do during COVID, and it wasn't until the government issued legislation that technically only affects employment standards, not common law, but until the government issued that legislation, that employers got a bit of a reprieve. Otherwise, there would have been thousands of layoffs that converted to constructive dismissals during the course of this pandemic. And that's because a lot of employers simply misunderstood that the entitlement or that the limits to temporary layoffs and the procedures that are expressed in employment standards legislation did not give employers a contractual right to implement temporary layoffs. These are two different things. Second, you want to reserve yourself the right to alter work locations, to implement remote work on a temporary basis, and to deal with other aspects of what's required in these various venues. You want to provide expressly that you can require employees to undergo certain kinds of screening. Outside of the unionized environment, that can include all sorts of random sorts of testing. And of course, when implementing things like that, you want to ensure you get some legal advice, but allowing yourself expressly to take temperature checks, to require employees to disclose on a confidential basis certain medical information in order to get access to your facility or to undertake certain tasks. Now that seems like a very prudent precaution. And in the unionized sector, developing a policy that allows you to do so if necessary in consultation with the union, because again, everyone has an obligation to take steps to ensure the health and safety of the employees. And that includes the union, of course, who have concern for their members. Amending the ability to amend a compensation, bonus, and commission. I'm suggesting up to 10%. Some have said that anything more than 10% is likely a constructive dismissal, and that employers can make changes that rise up to 10%. The law is actually a little bit more nuanced than that. And so my recommendation is that employers, when implementing these policies, or if they have annual sort of announcements of these different kinds of commission or bonus plans, that they would expressly reserve the right for any unearned, which haven't crystallized into wages, bonus, compensation, or commission. Another issue is to address ESA compliance problems in your contracts and in your policies. Go through them. I'll bet you that there are an awful lot of things that if you were asked, you would say, I know this is unlawful, but we don't actually do that. And if you answer yes to both of those, then I think you should be taking a moment to revise those agreements and those policies so that you don't end up in a wrongful dismissal lawsuit where an employee asserts that your contract isn't binding, your termination clause isn't enforceable, and they're entitled to 24 months of pay in lieu of notice instead of 8 weeks under the Employment Standards Act. And also, you want to define those rights on termination. This isn't a webinar on that, but we have seen dozens of decisions in the last year or two, and I would say 6 or 7 since COVID began, that have been very employee friendly and have struck down some provisions on various grounds that employers should all be going back to their contracts and having a look, not only at the compliance issues throughout the contract, but also at the termination language itself. And finally, if you're applying this to new employees, as long as it's lawful, you should be okay. But if you're trying to apply new policies or contracts or conditions of employment to existing employees, then of course that must be in exchange for some new form of consideration, something of value that they were not already entitled to in exchange for that bargain. So now we're going to take some questions, and we always like to try to finish on time. We only have a few, so that should be quite easy. Here's a question for you, Ryan.
Yes.
This is with respect to Christine Elliott's statement. And so maybe in fairness to you, I'll go back to Christine Elliott's statement from the beginning of the presentation. Here we are. So isn't Christine Elliott's statement against the Charter of Rights and Freedoms and the Ontario Human Rights Code under Creed? Do you believe that her comments are actually unlawful?
No, I don't, because I mean, I think that, first of all, I mean, she ultimately, I mean, if you're talking about, there may be, in generally speaking, I don't think it is. If you're talking about attendance at a place of worship, and if you were to start enforcing those rules against a place of worship, that could be a potentially, probably would be potentially a state interference in a religious institution, and then the court would have to determine whether that was reasonable or not. And it is quite possible, in the terms of a religious worship service, that yes, I could see that being considered unconstitutional and possibly a violation of the Human Rights Code. But it would be a charter argument, almost certainly.
Right. And for those of you who are not constitutional scholars, let's be clear. The way that the Supreme Court for decades has established sort of the test for making these determinations is first to determine, is there a violation? And then even if there is a violation, the question then becomes, under an old test called Oak, whether or not, or Oaks, whether or not that violation is permissible, nevertheless, because it is sort of necessary, there's a legitimate purpose, and that it is done in the least intrusive way, or the least damaging way to that charter right. And so there may be some circumstances where your charter rights are violated, but it's okay. And so this is a very nuanced question, and I sort of unfair to Ryan to answer in 30
No, well,
seconds.
I mean, the bottom line is, Jeremy, it means whatever the court's going to say it is. I mean, religious freedom cases aren't necessarily as given as much deference in Canada as they are, say, under the Constitution in the United States, in the present orientation of the American Supreme Court. It's a different test. I don't know what the court would do with it. I could see it going either way, frankly. Who knows?
Okay. Here's another question, I think, for you, Ryan. So let me just pull it up here. Why can't I pull this up? What steps should an employer take if an employee refuses to wear a mask?
Well, I mean, if an employee refuses to wear a mask, let's just assume we're in the world in the world that we're in. I mean, ultimately, you have to find out, why is the employee refusing to wear it. If it's not,
that's right. There was more to the question.
Yes.
Due to medical reasons, then what should you do?
Oh, okay. Well, then that becomes an issue, right? I mean, it is, first of all, I think you'd want to see, can you accommodate the employee by having that person work at home? And let's assume for a moment that that isn't possible. But if the person isn't able to socially distance, it becomes a very tricky it becomes a very tricky situation. But if he's putting that person is putting other people at risk, it may be, in my view, potentially an undue hardship to accommodate them. You may have to have them at home until until the pandemic is over. That may be because that person's putting other people potentially at risk. And if you can't socially distance around it, they're not wearing a mask, that may very well be a situation where it amounts to an undue hardship.
And I think that's where a lot of those cases that have been coming out that deal with that precautionary principle, like the one that I mentioned, the chicken processing facility, where the ministry came in and directed the employer to ensure everyone wore a mask, and the employer was trying to say, well, we've actually got studies that show that workers will touch their masks and it could lead to other kinds of health and safety problems and risk. And ultimately the labor board, at least in July of this year, was going to err on the side of making everybody wear a mask. So maybe we'll see, as you said before, a bit more development in the knowledge scientifically of the efficacy of masks. And then the answer to that question could change about what is and is not an undue hardship based on the risk to other employees of that individual as a source of infection.
Yeah, you compare and contrast that labor board decision with the St. Michael's Hospital decision from 2 years ago in the context of the influenza epidemic, where the arbitrator was incredibly skeptical about the evidence that was put forth about the value of masking in the context of influenza, which of course is a different condition. But anyway.
No, I agree. There's no simple answers to these questions, and the law, as the science, I think will continue to develop. We do have a couple of questions here which are more directed to employment contracts and things of that nature, as this is more of a health and safety and privacy related to COVID sort of a program. We'll not cover that here, but perhaps I'll answer some of those directly. We do have a question here, setting aside the employee claims that they can't wear a mask for medical reasons. What should we be including or excluding in terms of whether or not we're separating? Oh, you know what? This is also sort of a general employment standards and common law question. So those are all the questions that we have that seem to relate to the program that we've had today. I do have 2 questions from a couple of individuals that I will respond to directly when the program is done. But as we are at 1 o'clock and we do try to end these on time, I would like to thank everyone for coming in to hear this presentation. I know that Ryan and I enjoyed looking into these many nuanced and disparate issues in advance, and we look forward to future programs, and we hope you can join us. Stay safe, everybody. Have a happy and safe Christmas and New Year and holiday season. Okay, thanks very much, everyone.